Mr. Phillips, Mr. Lujan, thank you for agreeing to this interview. We're going to talk about the card. We're going to talk the love card, I guess. We're going to talk about the motion to set aside the verdict. But our audience needs to understand this from the beginning. And so my first question for you is from Mr. Lujan, because you're central to this. Your relationship with Judge Tydingco-Gatewood from the Hansen trial is central to this whole debate about whether there is a question of impartiality or partiality and bias with the jury and the judge. Can you explain first what you appealed to the Ninth Circuit for your client, Rufus Crowe, in the Hansen helicopters case, and then tell us what led to that motion, what led to that appeal?
Well, on March 21, 22, Gatewood severed Rufus Crowe, from the case, and the severance really occurred. And if you don't mind, I can. It's going to take a few minutes to explain.
Please, yeah.
All right.
Thank you.
Now, on March, the trial of that case began around March 8, 2022. I believe that's the first day of, what do you call that? After we selected a jury, that was the first day of testimony. Okay, by what the heck is that guy's name? But anyhow, he was represented by Peter Terrace. All right, and the guy, and it'll come to mind, his name. He testified for several days. Then on the 17th, March 17th, I thought I had COVID. It was a Thursday. And I thought I had COVID. So I called in and said, I may have COVID, so I'm not coming. So there was no trial then because I wasn't there. But for some reason, there's a transcript of Gatewood talking to Marie Miller.
She was one of the prosecutors against Hansen Helicopters.
She was the main prosecutor.
Main prosecutor.
Yeah, she was the main prosecutor, and she was from the Department of Justice, I believe. Okay, and she was the main prosecutor. Okay, and so there were three prosecutors. So she and Gatewood were talking, and we have the transcript of that, in which Gatewood is saying that maybe you should get rid of Lujan. Okay? And I believe that the reason for that, the reason for that is in 2018, I did two trials in front of Gatewood. And that was in the Moser-Martinez trial.
Yes.
And both of them ended in a mistrial, or hung jury, rather. Both of them. And so eventually, that case, the U.S. attorney filed a motion to transfer it to California. So, it ended my participation in that Moser-Martinez trial. And so I believe that, when Gatewood and Marie Miller had described this, knew that, because she said to Miller, you need to get rid of Lujan. And I believe that has to be related back to the two Moser-Martinez cases.
In the transcript, there's no other context behind her statement about getting rid of you?
Oh yeah, there's none other than to use it as an excuse, Of course, get rid of me because, I'm using the excuse that you have a lot of witnesses, it's costing you a lot of money, And that, then I guess one cures, get rid of David Lujan.
Okay.
Very simple, and that's what. In order to get rid of me, they had to sever Rufus. Yeah.
And that would severing Rufus, which was your client, Rufus Crowe, from John Walker and the other defendants, would allow the government to continue the trial without you and Rufus Crowe, and then you guys would have a separate trial.
Well, that's what they thought.
Okay.
They thought, which turned out to be wrong because of double jeopardy.
Yes.
There was no really manifest necessity, that required that Rufus, be, let's say, removed from the trial and to, what do you call that, and he can be tried separately in a different indictment.
And that's what the Ninth Circuit eventually ruled, was that Rufus Crowe could not be, the case had to be dropped or dismissed with prejudice because of double jeopardy.
That's right. But before that, once she got rid of Rufus, they were, what do you call that? Eventually, we filed a motion to dismiss on the basis of double jeopardy. Okay, but that was months later, after March 21. So, but what really happens is, this is to me the core of everything. All right. So, Gatewood, and just using timelines, So let's say, after what happened on March 21 is that I came back from being, it's Monday, so I came to court and I said, I had gone and seen the doctor 2 times, and they told me I was assured that I had no COVID. So around 7:30, 8 o'clock, we had a chamber conference. And in the chamber conference, the defense counsels were all present. The court and its staff was present, and the prosecutors were all present. But then, there was a bunch of other people that were not parties. From, they're not court people, they're not, prosecutors, they're not defense people. And so Gatewood asked Miller, who are all these people that are coming in for chamber conference? And Miller says, oh, it's my boss. The lawyer for Department of Transportation. And the name is in the transcript, okay? And so, of course, remember, I had not been to court, since the 16th, okay? And so I'm just curious, what the hell is going on? How come so many people? Now, then...
Wait, the judge called for this conference in her chambers?
We always have chamber conference in the morning.
Okay.
Before trial.
Okay.
But we don't have visitors join the chamber.
And so that's what was weird.
It was weird. But then Miller started to talk about that during the weekend, that, the FBI received, a, what do you call this? What's that thing?
A message.
The message.
I have to disclose at this point that this is where I personally am. I personally have an involvement and a conflict here, because the weekend that you're talking about, that was when I received a Facebook message to Kandit from a Amber. I can't remember the last name, but the account has since been terminated. But it talked about, the Facebook message talked about the Hansen trial, and how there was inside information about how the jurors were discussing the case and had already decided to rule in favor of the prosecution or opposed, because they don't like David Lujan, and they and so we reported it to the FBI. I called the FBI, reported it to the FBI, and then I don't know what happened after that. And I did not know what happened after that for several weeks or months, but I'm sorry. I have to disclose that. Please continue.
No problem. I agree completely with what you said. But I wasn't the only one that didn't know about that, because that was a Saturday, March 19,
Yes.
when you received that and you forwarded it to the FBI.
Yes.
So Marie Miller mentioned that in chambers on the 21st. And when she mentioned that, of course, I'm wondering what the hell happened here. I mean, I have no knowledge about this, about this message, I had no knowledge about it. And so I believe that Miller did that on purpose, So of course, and so she disclosed that it was the first time I ever saw it. I asked to read it, and of course, it says, that the jury hates David Lujan, and that the jury has voted already to try Rufus Squirrel, rather, they voted that Rufus Squirrel is guilty, and that Rufus Squirrel will go to jail. So, of course, when I saw that, I tried to argue with Gatewood, and I said, look, Judge, in the Martinez Mosa case, 2 times we had issues with the jurors in the 2 separate cases, and we asked you to interview the jurors individually there. So why can't you do the same thing here in the Rufus case?
And according to the court transcript, Judge Tydingco-Gatewood said it was not necessary. She did not want to alert the jurors to the matter.
Well, I think it's even more that she did not believe it.
Yes.
She did not believe that Facebook thing. She didn't believe that. Didn't give credence. That's why.
Even though the FBI had told her in this, according to the transcript, the FBI agents had told her that they personally interviewed us. They personally saw the messages. We showed them the account, and then she said that she did not believe it. Yeah,
that's right. And so in the chamber conference, so she kept talking to me, asking me, trying to convince me that Rufus really should, because there's testimony that had already come in that made Rufus look bad. And Rufus, sort of likes to joke and, say certain things about women. And so she was telling me, trying to, convince me that it might be in Rufus' best interest to be severed. And so I asked, that, well, I can't make that decision by myself. I have to talk to the client. So I was given 15, 20 minutes to go talk to the client. So outside of chamber conference, I went and met with Rufus, talked to him, came back, and I told the judge that Rufus does not want to be severed. Okay? And so, of course, and so eventually, we finished chamber conference and went back into, returned back to the courtroom, so that we could put on the record what occurred during chamber conference. And I don't think that was done openly. That whatever took place, reporting about chamber conference, I do not think was done openly, to the public. So once that was done, then she began trial for, that morning. She began trial, and then once it began, within minutes of the case beginning, she then said that she's thinking that she wants to sever Rufus Squirrel. And again I said, but Rufus does not want to be severed, Judge. And she, of course she said, oh, no, she can be severed. Now, to Marie Miller's credit, she did say that, Your Honor, I don't think you can do that. You have to do a manifest necessity analysis. And then Gatewood said, that, oh, no, this is only a Rule 14, Rule 14 severance. And so, I've researched this thing, and Miller immediately changed her position and said, "You know what, Judge, you're right. Huh? You're right. You can do this. There's no need for a manifest necessity analysis. You do have the power." And that ended Rufus. So, of course, before she did that, I spoke to Rufus again. I tried, and Rufus did not want to, to be severed. I asked for 2-day continuance, and she refused to give me a 2-day continuance. And I said, I need to consult a different lawyer because of that message that said that the jurors hate David Lujan. And so I feel that maybe I should not be the lawyer anymore at this point for Rufus. But she refused to give me 2 days. Then I asked for 1 day. And then even one of the other defense counsels, Mike Martin, even he jumped in and said, "Your Honor, they joined that." It says, "Why don't you give David, 1 day?" And she refused to. She refused, and that's when, she decided to sever us. But this is where where things really, this is the first time something, whatever I'm telling you, a lot of it is speculation in my part, but believe me, there's evidence that supports it. So using 10 o'clock as the time, 10 a.m.
March 21.
Yes, March 21, that Rufus was severed. So at 10 o'clock, we go, she severs Rufus. Me and Rufus go into the defense counsel's, chamber where they meet. And in there, I could see everyone was giving me a dirty look, me and Rufus. So I just told Rufus, I'm going, I better get up. And I'll give you a call, tomorrow. Relax, I'll give you a call tomorrow. All right? So that's around 10 o'clock. Now, we have information that say that, once the, Rufus was severed, of course, the court ended momentarily, okay? And then Marie Miller, the prosecutors, and their boss, are reported to have been standing by the elevator right outside the
the judge's chambers or the courtroom. Yeah.
Okay, and someone overheard the lawyer say to Marie Miller, "Don't you realize what you people did? You've given Rufus Crow. You've created double jeopardy." Okay, and so why that's important is that within minutes, Matt Martin, the lawyer for, what's his name? John Walker, the lawyer for John Walker, called up Gatewood. Okay? When I say Gatewood, I mean, asked for a chamber conference. Okay? And so then, at 11 o'clock, Walker and the other defense counsels all met with Gatewood. Okay? And we have the transcript of the entire thing of what happened in there. And in that, Mac Martin told the judge, he says, Judge, Rufus Crow wants to plead guilty, but we don't want David Hunt representing him. Now, at that point, this is after Gatewood has severed Rufus.
And only within 1 hour of it happening.
That's right.
Okay.
At 11 o'clock, like I said, we have the transcript. At that point, Gatewood You know, you would expect that Gatewood would have said, you know what, there's nothing anymore. Rufus is not a part of this trial. He's no longer part of this case. And if you want to talk to Rufus, go through David Lujan. But she didn't say that. They were discussing how to go about this, meaning the defense counsel, you know. And when you read the transcript, and we'll give you a copy of the transcript, you'll see what the defense counsels were telling her to do.
Can you explain to our audience why this is significant? That if would I be correct by saying that if Rufus Crowe pleaded guilty, he would have taken the rap for everybody else? Is that what would have happened?
I believe that was the game plan by the defense.
The other defense counsels.
I believe that. Now
to get John Walker and others off.
Well, I'll tell you what. You need to understand. There's a lawyer by the name of Ed McConwell. And Ed McConwell is an 80-some-year-old idiot, really. You know, and who doesn't do criminal cases, okay? And his local counsel was Tony Perez, okay? Now, so, you know, another lawyer involved was Peter Perez, the brother of Tony, who's also representing the, you know, the, what's his name? But anyhow, he's representing the only person from Hansen that was cooperating with the government and was testifying at that time.
Oh yes, their prime witness.
That's right.
The government's
their
prime witness. Yes.
So you've got Peter Perez being the lawyer for the snitch. And then you've got Tony, who's the local counsel for McConwell. Now, McConwell is a guy who, you know, who was always kissing Marie Miller's ass. Okay?
Even though he was a defense counsel.
Even though, in fact, I have written letters to him telling him to stop talking to them. You know, because he's supposed to be representing, you know, I mean, well, you know, he's part of the defense team. Okay? But he's a guy that always talks to them. Always talks. And, you know, like, and so in any event, so, you know, of course, he was part of the group that went and met with Judge Gatewood.
At the 11 a.m.
At
chamber
the
conference.
11 a.m. meeting.
Okay.
And they were all giving their opinion of how to do this.
Of how to get Rufus Crowe to plead guilty and to get you off of the case. And this is all in the transcripts of that
It's
day,
all in the transcript.
which was later unsealed. It was sealed at the time, but later unsealed.
That's right. She refused to give that until much later.
Okay.
Okay? But, you know, so then after that, okay, the prosecutors were called to come in. And the prosecutors met with the with the defense counsels. And then they said, oh, Judge, well, you know, we'll take this away from you and we'll talk to the defense counsels. So, you know, that ended Gatewood's role that time. But, you know, Gatewood, what do you call that? So that was a Monday, the 11 a.m. after that. Okay? Then on March 22nd.
The following day, Tuesday.
Following day. Okay? I got a letter. No, I'm sorry. You know, I spoke, you know, I mean, I didn't bother Rufus at all. Okay? And then on March 23rd, around 1:30, my office receives a letter, you know, and a sealed letter, and I didn't see it until 4 o'clock because I was not in the office. And it's a letter firing me by Rufus. So, you know, of course, And I've got Rufus, permission to disclose this. And so I called Rufus and I asked him, what happened, Rufus? Why would you do that, And he said that he keeps getting pressure. So this is at the letter was at 1:30. I didn't talk to Rufus until around 4:30, something like that, in the afternoon, okay, on Wednesday. But I learned that, there were 3 federal agents that went to Rufus' house because they understand Rufus wants to plead guilty. And so to Rufus' wife's credit, she got them to sign their names and she took pictures of them.
Can we have their pictures and their names?
Of course,
Thanks.
we'll be more than happy. I'm sure that they like to be publicized, They can become famous federal agents, and they were there. And Mrs. Cole all fucks them, because she got to take a picture of them. But in any event, so of course, that's what happened. Now, let me move back to, March 21, right immediately after the severance, and when I went into chambers, okay? Rather the defense counsel's, conference room. So like I said, I was in there just about 5 minutes, then I left because I felt uncomfortable. But it's my understanding, and again, I've got Rufus' consent to disclose this. When out of my absence, Tony Paris told Rufus, don't worry, we'll find you a better lawyer. Okay? So that's Monday. Okay? At 11 o'clock, or rather 10 o'clock, you'll find a better lawyer. And then he said, we'll call, John Terlahi to represent you. So I learned about that much later, until I believe Wednesday afternoon, the 23rd, when I did talk to Rufus. So Rufus came to my office on Thursday around lunch hour, and he told me that a meeting had been set up by Tony Paris for Rufus to meet with John Terlahi. And Rufus, I told him, go and meet with
John Terlahi is now the local judge, correct?
Oh, the judge, and not only that, a deacon.
Yes, that's right. Okay.
Don't forget that, So, what do you call that? So Rufus goes there, and, to John's credit, John said that, hey, why would you want to change lawyers? David's best trial, criminal trial lawyer. Okay? Why would you want to change lawyers? So, John said, he doesn't handle this type of cases. So, so that's a Thursday. So on Friday, Rufus and I spoke, and then on Friday morning, and he told me that they had set up, McMartin had set up a meeting for Rufus to meet with, J. Areola on Friday. So on Friday morning, Rufus goes and meets with J. Areola. And Rufus was with Turner Cap. And to J. Areola's credit, Turner Cap, is represented by McMartin, Ed McMartin. And, of course, he wanted to be present while Jay and Rufus talked, and to Jay's credit, Jay said, no, this is attorney-client, okay? And Jay disclosed to Rufus that he received a phone call from Martin, and he received a phone call and said, we're looking for a lawyer to represent Rufus to plead guilty. And Jay told him that he'll do it for $250,000. And so, Mac, told him that money is no object. Don't worry about it. Okay? And so, Rufus meets with Jay, after receiving that information from Jay. And then, of course, it didn't work out. For some reason, Rufus didn't,
He didn't want to plead guilty.
well, he didn't want to plead guilty. That's right. And so then, after that, after that, that ended that. Okay? But, of course, then I got into, a bunch of arguments with the U.S. attorney, and in which I told them, I represent Rufus. So why are you guys not coming to me? Huh? And so, of course, eventually, there's a lot much more here. But that ended, that ended Rufus, because in the end, of course, Rufus, was not going to plead guilty.
So Rufus hired you back as his attorney?
Yes.
Okay.
Hired me back. And so, but here's the thing, all right? I believe that, when I'll move to the other case, and the other case is the Bingo case.
Yes.
That I believe began in March,
Yeah.
around March.
Yeah.
Okay.
So-
But before you get there, I just wanted the accusation here to be clear. What happened, what transpired from the Hansen case in the severance of Rufus and all the meetings that happened and all we'll call them transgressions that occurred involving the defense counsels, the prosecution, and even the court, eventually led to an embarrassing situation for the judge, where a ruling of hers was overturned by the Ninth Circuit, which led to Rufus Crowe being let off with prejudice,
Right.
the dismissal of all charges with prejudice.
Right. Okay.
Do you feel that the judge has held some sort of animosity against you because of that?
Of course.
Okay, which is why on April 3rd, you walked into the courtroom when you made your appearance for Michael Marasigan in the bingo trial.
Right, but before we get to that, okay, within weeks of Rufus being severed, okay, I filed a motion, to dismiss the the indictment, with prejudice on the basis of double jeopardy. So the judge, of course, the government opposed it, and then the judge issued a decision in which she denied the motion. Okay? And then Rufus hired Ben Coleman, an appellate lawyer, since I don't do appeals, and hired, but of course, I think I was with Ben Coleman as far as being on the papers. All right. So Ben is the one that filed the appeal after Gatewood's denial of the motion for the double jeopardy. And so the Ninth Circuit came down on, I believe, November 2023, okay, in which the Ninth Circuit, by a 2-1, vote, okay, the majority ruled that, in favor of Rufus, that, that there was double jeopardy. And so the Ninth Circuit not only ruled in favor of Rufus, but, issued an order, that Rufus is, completely exonerated. And so, Rufus, can never be retried again. All right? So that's what happened. Now, that was November of 2023. Okay? Now, we go to Marasigan's case now. Okay? So, remember, in the Ninth Circuit appeal, none of the things that I mentioned earlier was an issue. It was never an issue. there was never any discussion or as part of the appeal. There was never any mention.
The judge's impartiality was not
That's
a
right.
not,
Not
a
an
part
issue
not an
at
issue
all.
in the double jeopardy
That's right.
Ninth Circuit case.
That's right.
Okay.
Okay,
And you never made this a public issue until right now.
that's right.
Okay.
I never mentioned it until I got involved in the bingo case.
Okay. And that was on April 3 when you first started to make a mention.
Yes,
Okay.
it was April 3rd or 4th that I filed the motion. Okay? And because, Gatewood wanted me to begin cross-examination of, the government witnesses,
Mr. Leon Guerrero.
Mr. Amo. And, of course, I told the judge that I'm ready to cross-examination. However, I would like to, make an oral motion. And the oral motion was that, the judge can't be fair. Okay? Because of what happened between me and her in the Hansen case regarding Rufus. Okay? And so, of course, she did not like it. She denied it immediately. Took a 20-minute break that turned out to be around 2 hours. And then she issues an order, right? A written order, where she says that, that Marsigan's lawyers, Mike Phillips and myself, are to file a brief, at 3 p.m.
3 or 4, yeah, something like that.
At 3
I
p.m.
think 3 p.m. that day.
Yeah, 3 p.m. that day.
We left the proceedings.
Huh?
I think we left to go work on the
Yeah,
Yes.
yeah, on the motion.
Yeah.
And then the government was given until lunch hour
The following day.
the following day, which was a Friday, to file its opposition
and then 5 p.m. for your
Fi-
reply.
for our reply.
Yeah.
And then we filed that, and then, of course.
This
the
was.
rest-
I'm sorry. Can you tell our audience what was it that you were ordered to file by 3 p.m. that day?
Well, my motion, rather our motion, requesting that she disqualify
Okay.
herself because she cannot be fair.
And you explained this according to
And-
the transcripts. You explained why, and it had to do with the Hansen helicopter
And I
case.
said, she said, well, what's your basis? I said, Judge, because you don't like me, you hate me, and truthfully, I hate you. And, because of what happened in the Hansen case, you could never be fair with me anymore. Okay? And so, of course, that's what happened. And so eventually, probably 3 weeks later, 4 weeks later, she files, after we file our motion, she denies the motion. Okay? So, what do you call that? And so that, I believe, and so there were other things that occurred during the trial and after, during the trial. And so, can we talk about the
card.
card?
Okay. Well, I kind of want to discuss other issues before getting to the card.
Okay. no problem.
And it was from my reading of these transcripts. Now, Mr. Phillips, there is an indication from the transcripts that even prior to Mr. Lujan making his initial appearance or his formal appearance as Marasigan's counsel, right, that the judge was making comments in front of the jury about delay tactics. Can you talk about that?
Yeah, what I remember, which because obviously Dave's history with the judge, I was not a part of that. So what I saw from my vantage was Mr. Lujan had contacted me and told me he was driving to court, and he said, I'm not feeling well. That was the day after, as I've described to the court, and I think it's in the transcript, probably the most brilliant cross-examination I had seen.
Do you remember what date that was? The date?
It was the day before Mr. Lujan filed the motion.
Okay, so it was
or 2 days.
April
Because
1st then?
yeah, it was the cross-examination of Mr. Leon Guerrero.
Okay. And at that time, Mr. Lujan was not Mr. Marasigan's counsel.
No, he was.
He was.
Yeah.
But he was making his appearance on April 3rd.
No, he was part of the case,
Okay.
and there are a couple other things that had happened. Voir dire was very, very different from what we've experienced before.
Okay.
And so there was the very heated exchange I remember between Mr. Lujan and the judge.
In front of the jury?
Well, it's in front of the jury, but they're not supposed to be able to hear because they turn on what they call the white noise. So yes, especially reading a transcript, it would appear because they are there, but I
But
we're sure that
obviously
they're
there
not
was an
supposed to be
exchange.
listening.
Okay.
Yeah.
But they were there.
They were there.
Okay.
I don't remember them being in the courtroom at the time that I informed the court that I just received a call because it was before court. We were there real early, and when I tried to open the door, it was locked, and one of the marshals said, "Oh, Mike." One of the clerks who was servicing us that time in court, Mr. Tenoyo, was in the clerk's office, and just go down there. So I went down, and Dave still happened to be on the cell phone. So I just handed the cell phone to the clerk, and Dave spoke directly to him and told him exactly what he told me. I'm on my way, and I'm not feeling good right now, and so I'm going to go back home. That was the surprising part when we relayed that to the judge. And it's in the transcript. Her reaction, her response was, I've been suspicious, and just kind of went off. And so I had made the record clear that as far as I saw and knew, those allegations were baseless because there wasn't anything.
You never hear a judge speaking that way. And was this in front of the jury, this specific conversation?
No, I don't believe that her comments at that time were in front of the jury.
But did the judge ever make comments about suspected delay tactics in front of the jury?
I don't remember the judge making those comments, but of course, it's a very long trial, and at times things get very heated, so it's possible. And we all have our individual responsibilities, so it's possible something like that may have been said, but at this moment I don't remember it. What changed was I relayed to Mr. Lujan what had happened, and I think, at least from what he had told me, is obviously she's very, very upset from the Hansen issue. Mr. Lujan may not have good feelings, but he wasn't taking them out on her, and so.
Well, you can't take it out on the judge. You don't have the rules are not reversible, right?
Yeah, he doesn't run the court.
Yeah.
So, yeah, I mean, her decisions are final, and so when I relate to him what she had said about him outside of his presence, the next day he came and he in fact I think he might have come in maybe a minute or two late because he had prepared a motion to recuse her, meaning to disqualify her. And when she asked, "Are you ready to go forward?" he said, "Yes, but I've got something to say first." And so he said I should take the lectern, and she said, "Yeah, you should." And then that's when he confronted her regarding what he thought, the hard feelings that she harbored, and then he outlined what had happened before, and but that's one part that I think is missing, is that Mr. Lujan just didn't walk in and file that motion. It's after the judge, outside his presence, was telling us about her suspicions and stuff like that.
Which is
the record was.
You've been a lawyer for a long time. Both of you have been lawyers for a long time. That is not supposed to. It's your understanding that's not how a judge is supposed to be.
Well, I've not had that happen before.
Okay.
I could tell there's something here, and I'll tell you, there's two reasons. One is because of that, and two, everybody else asked in the courtroom. I didn't take a survey, but the other attorneys and others saw that the night before, because we were going we were working through the evenings. Mr. Lujan did not look good, and he even left tissue on the table. And so I mentioned that to the court. I mean, unless he's really staging it, because he was having difficulty with his leg, walking around. Everybody else saw it. The judge said she did not see anything.
But one of the points that you made in the what I read in the transcript, one of the points that you made was that the judge was only commenting about these alleged delay tactics on the part of Mr. Lujan, but did not comment or make any suspicion of delay tactics on the part of Ms. David when witnesses would not be able to show up.
Oh
on
yeah,
time.
it was clearly that, and I believe I mentioned that orally, as we say, as part of our argument, because they had a 90-year-old man, and we were accommodating him. Mr. Lujan was accommodating him. I mean, he was in the middle of cross-examination, and things stopped, and at the same time he was patient. They were telling us when their witnesses would be available, and usually what happens is you call a witness and it goes all the way through. That's important to the jury. Just like if you interview people and you break it up over a number of days, it's not the same as the ebb and flow, as they say, right? And able to really see things in context, as opposed to.
And the judge never made an issue out of that when the prosecutor.
No, not at all. Not that I can remember. In fact, I think the court went out of its way to make sure that Mr. Longuero's dignity was maintained.
Okay.
Yeah, without doubt.
How often were the defense and the judge at odds on any matter in front of the jury?
Maybe 10, 20 times a day. I mean, that was a natural. It was a case that from the very beginning, I think set the parameters for that. We didn't participate much in what we call voir dire. So you really have, in my opinion, blind jurors. I had to spend half of my closing argument talking to them about the presumption of innocence, what reasonable doubt means, basic things like that, because the judge would read a paragraph on each one, and that's it. And she did that a little bit at the beginning and much more at the end, but there's no way, because we were not allowed and didn't have any meaningful discussion with the jurors to see who's able to understand. It's not an easy thing to understand. Most attorneys don't do this type of work. So with all due respect to my colleagues, I would say most of them, while they understand it's out there, they don't really understand the meaning of it and how it works. And obviously that's one of Mr. Lujan's many strengths is reaching people at a level that they can understand. That can only happen if you're allowed to talk to them, and you're only allowed to talk to them during voir dire.
And you're saying the judge would not allow that?
No, there's no meaningful voir dire. I mean, Mr. Lujan just turned to me and said, we're not going to do this. Go ahead, you do it. And so I think I probably asked like 3 questions or something. I mean, there just wasn't something meaningful.
Can we get to this? Can we inform our audience a bit more about this issue about the voir dire? This is at the beginning.
Voir dire's like this.
This is.
We're able to have a conversation like this.
During jury
clarify
selection?
things, yeah. And when I ask you questions to see, if you're the type of person that can be fair, I'm able to discover lots by what you say and how you react to my questions.
And this was during the selection of the jury.
Yes.
Correct. Mr. Lujan, did you find this to be bizarre that you weren't allowed to ask more probing questions in the selection of the jury?
Okay. Look, I've done way over 700 jury selections, and I've never done anything as bad as what occurred there during that. And so during the jury selection, it was very clear to, I really believe all defense counsels, that, that the jury selection was totally different from our experience with Judge Gatewood and with other judges. And so we spent a lot of time at sidebar arguing with the judge. And to the point that I told the judge, Judge, you don't know anything about jury selection. You've never selected a jury. You've been a judge You were a prosecutor, you did a few trials, but, you've been a judge since 2006. So you don't know anything about jury selection right now. That's what we do for a living. But she refused to allow us, to ask certain type of questions or allow us time. And that's why in the end I just told her, forget it.
Okay, and you said that this happened during sidebar, so that means that the jurors were actually in the courtroom. They might not be able to have heard what she said, but there were sidebars that occurred which
You're
obviously
correct.
showed
You're
that there was a
correct.
conflict happening
Yeah,
between
you're
you and the
correct,
judge.
because, of course, it was during jury selection that we had the issues with her.
So this sort of conflict between defense and judge was already apparent to the potential jurors from the very beginning of the trial?
Oh, there's no question in my mind. I mean,
Okay.
it was a very animated sidebar
Okay.
with the judge, and so while the jurors may be, maybe 20 feet, 30 feet away, I'm sure that they can, they can discern that something is going on.
They know that
that's
there's a
not right.
conflict.
That's
They
right.
know that. Okay, and
That's right.
you said that 10 to 20 times a day on average there would be some sort of
More, yeah. In fact, I'm sensitive to it because it was new to me, but it felt like maybe 60-70% of the objections came from the judge, not from the prosecutor. And so that was, it's okay to have two prosecutors on one side, but when you have two prosecutors on different sides and one's the judge, it felt like that, because now most of that was evidentiary and formation of questions and all that, but it's very disruptive, and it does signal to the jury that the judge is on someone's side, at least on that issue. You're asking a question, and the judge says, Mr. Torres, approach the bench. Yeah, the jurors know exactly what
that
happened.
Mr. Torres is in trouble.
Yeah, well, you've done something that the judge doesn't think is right.
Yeah.
When you come back, sometimes it would be 2, 3, 4, 5, 10 minutes. Maybe you don't ask that same question, and of course the jurors are always told not to hold that against us, but that it's a natural conclusion, and it's a natural feeling after a while.
Yeah.
That
Can-
maybe we're doing something wrong.
Can we get to a comparison between the treatment of the prosecution and the defense? So if there was some sort of odds between defense and judge 10 to 20 times a day on average,
We were probably up there about 30, 40 times. There's a lot more than that, but at a minimum, yeah.
by comparison, what
Yeah.
about how often were the prosecution and the judge at odds?
Well, I remember one time, because the prosecutor had such a nice comeback when the judge was asking a question early on. Aside from that one time, I don't remember.
One time throughout the trial.
One time that was significant enough to remember, yeah.
Okay.
Because otherwise, when you're stopping the defense from asking questions or calling them up, it's not to talk about our dress code. It's because because the prosecutor hasn't raised an objection or some similar reason, but it's for no reason other than to stop us from where we're going is I would say 90+% of the time. Otherwise, and there's many ways to do that. I can ask you, Mr. Torres, where are we going? Or Mr. Torres, you can't go there. Or Mr. Torres, whatever it is, we're being called up because we've asked the question, and the court has problems with it. Ordinarily, it's an adversarial system, and so it's prosecutor and defense, right? You and me, back and forth.
But prosecutor
And-
versus defense, not.
Yeah,
the
generally
judge.
the judge, 99% of the time, the judge is a referee. Yeah.
So in this case, what you're saying is what the jury saw was that the judge was favoring the prosecution over the defense.
Though, it's way before my time, but I have watched the movies before there was sound, right? You get to see a movie, and after a little while, you're able to figure out everything, even if there's no audio, right? Just by looking. So, the jury's not stupid, and they become very familiar with what's going on, because lots of times it starts with the speaking objection, and that might even be coming from the judge. But then we end up at sidebar, but not there for any reason other than what just happened. So if you're talking with someone and then an issue comes up, and then I call the two of you to me, what's about that issue? I mean, clearly you're not calling, it wasn't like, oh my God, I forgot to talk to you about lunch today. No, not at all. It's about that specific issue at that moment. And so yeah, intentionally, unintentionally, that's the effect it's having, big time.
Mr. Lujan, how clear was it to you that the jury was seeing that the judge did not like you and that therefore the judge favored the prosecution?
Oh, it's probably the clearest example that a jury could, view or witness. Because in truth, I did tell the
In front of the jury?
in front of the jury.
Okay.
I told her that. And that because, in my opinion, the judge is just not fair. So might as well call an ace and a spade a spade.
So let's get now to the card. So after all this, after you have all these odds between you and the judge, you make the motion, she denies your motion, the trial goes on.
One more significant constitutional part there.
Yes, of course.
Troy, the Constitution, or again, have it's called the confrontation clause.
Okay.
If you're going to be put on trial, then the witnesses that come in, you're entitled to face them. Mr. Lujan is an agent for a defendant. He's entitled to face that witness, or have the witness face our client. But the judge allowed a witness to wear a mask through the whole thing, and it was causing a number of problems. One is, especially with Mr. Lujan's ability to ask very probing questions, she was able to cover her expressions. And secondly, the judge had trouble hearing her, I had trouble hearing her, and Mr. Lujan had trouble hearing her. So at a certain point, when the judge, and I believe the transcript will bear this out, if it's not exactly like this, it's something very close. The judge refused, even after we had, I think it was even after we filed our briefs on it, our paperwork, to show that it's very important. She wouldn't have the witness take the mask off, and so Mr. Lujan could not hear, and it was getting worse. And I think the witness, again, unintentionally knew that. And so it just kept going lower and lower to a point where I said the record will bear out. The judge made mistakes with regard to what the witness was saying. I made mistakes. Mr. Lujan definitely made mistakes. We said, well, then, Your Honor, if you're not going to do it, then I'm going to have to cease. He just walked off. And because it became comical.
So this goes to the defense's
The
or
confrontation
the
clause,
defendant's
yeah, I mean,
Sixth
we filed
Amendment,
that
right?
motion on that. That's a constitution, not a legal law thing. It's the Constitution. It doesn't get any higher than that in court. And so when they stopped Mr. Lujan's ability to have a meaningful cross-examination, then he just said, okay.
Is
then I'm
this
gonna have
one
to cease.
Sun Min, the witness?
No, it was
Minda.
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 Minda
It's a
Nicholas, yeah.
Okay.
So Nicholas.
So the judge gave me a day to prepare, and then the next day she offered us the opportunity to continue cross. So I took it and finished.
Okay.
But I made mistakes because I couldn't hear the lady, and the judge made mistakes, and so we're all correcting each other at different times. Either
all of this in front of the jury.
Oh yeah. And don't get me wrong. You ever ask the jury, can you hear? Absolutely. Anybody need to know? I've never seen a jury, except the one time the lady raised her hand and said, Your Honor, could we go back to regular hours? But aside from that, jurors are just, they feel they're special guests there, and so they don't want to intrude on anybody. But I'll tell you, at our defense table, because there was a lot of us, and we always ask people that are, in the audience, what they're hearing and all that, and they're hearing or not hearing what we're hearing. Now, when you're a prosecutor, or really anybody on direct, and you and I have either rehearsed your testimony, or you know what I'm talking about, then it's a lot easier for me. Quite frankly, I don't even really care about your choice of words, because you're my witness. But on cross-examination, when I'm not able to pause for 5 seconds to see your facial reaction, that tells me where to go next. I can tell when I've asked the question that there's something there, and when there's nothing there, right? Or you take another path, or you're convinced, okay, that's the answer. We were denied that because we couldn't read that witness more than than this. To illustrate this point, and it's nice because they were not my words during the oral arguments. The attorney, Mr. Gavers, for Mrs. Chen, described it as the old cowboy movies where they come on the stagecoach and they're robbing a bank, and they wear that mask so you can't identify them, even in the saloon later on. And Mr. Rosano, he described it like the concept of a poker face. When you're playing poker, you look at that person in the eyes and you look at their reaction, and that tells you whether they're bluffing or not. We were denied all of that. My contribution to that was because, and this from doing audio, that about 50% of the lines that we see on TV are actually voiceovers that you come in the next day and you get your lines right, because it's really hard to have everybody mic'd up correctly so they come in. So even wearing the mask, the cowboy movies are really not accurate, because most of them I believe would come in the next day to do their lines. Really tough to hear somebody with the microphones that they have set up at the court. If you've been there, they're not top of the line. They would not be considered professional in audio. I'm sure for the courts they probably are, but in audio, they wouldn't even make the stage for a band. I mean, they're very, very poor. And,
so as a separate matter then, separate from the issue of bias and impartiality, is the issue of your client's constitutional right being
because it led to me finishing the case.
Okay.
Yeah, because Mr. Lujan said, well, if basically, employing with the judge, if she wasn't going to do anything, then he can't go forward. It became comical.
Okay.
Yeah, I mean, I don't think the judge found it funny when she got it wrong, but I say that in a way of describing how bad things got and how slow they went, because we couldn't see the person, and it was very difficult to hear the person.
Okay.
Yeah, very, very difficult.
Okay.
And when that goes on hour after hour after hour, not hearing you for a few minutes, I think people can tolerate that, but not hearing you for a couple of days, and you've got attorneys that are trying their best, going over things that are very, very important, it's very, very frustrating. And so, it wasn't my client's choice to say, hey, why don't we have Mr. Lujan sit down and have Mr. Phillips finish the cross-examination? That wasn't his choice. That was a necessity, because all we asked, in fact, during my part of an argument that, it wasn't an argument, actually, it was questioning, the judge had announced her ruling and then had asked the witness some questions, then said, you guys have any questions? I said, yes. So I had asked her just to pull down her mask. There was no trouble. I mean, she's not the only one to be uncomfortable, in a situation like that. I think everybody in the room is uncomfortable, but when you're in a criminal proceeding and somebody's life is on the line, they have that right. Now you can put up plexiglass if you're afraid of COVID or things like that, but they are entitled. And there are some exceptions, Troy. For example, if you have a little kid, a child that has been harmed, or at least allegedly harmed by the defendant, there are some exceptions to that, but none of those exceptions fit here.
They didn't apply here. Okay.
Not at all. But I find this important because it led to Mr. Lujan having to say, okay, then I think the word he used was cease, and I have to cease.
Okay.
And that's what he did, and then I jumped in. Yeah.
Okay. Can we get to the card? Can we get to the card? Because what happened?
Can we take a break?
Yes, of course. We're going to take a break after an hour and 4 minutes. We are back on the record after a few minutes break. Thank you so much, gentlemen. Again, Attorney Phillips, Attorney Lujan. I want to go to the card. After all of those odds between you and the judge, after your motion to disqualify her, after she refused to grant the motion to disqualify, after the going back and forth with the witnesses and the direct and cross-examination, the trial goes on, and before the jury reaches a verdict, the jury made and sent a card to the judge and her staff. Can you talk about that, Mr. Lujan?
Sure. Well, honestly, in the end, probably Mike would be the better person.
Okay.
And I'll tell you why. Because the closing argument of this, I believe, was May 6th.
May 6th for us, May 7th for the
May 6th.
U.S. Attorney.
And by the defense, and then, well, in fairness to, what's her name, Maravik. Maravik gave her opening closing argument on May 6th. And then the three defendants gave their closing argument, on the 6th following that. And Maravik got a chance, to finish her, her closing argument on May 7th, the morning of May 7th. Okay? And so I believe that's the same morning that I left for Thailand. Okay? Now, so I was not present in some of the things after that. It is and you're aware about, some transcript by Gatewood. And there's, I think, a May 13 transcript. And that would be the same day of the verdict. Sometime in the afternoon, on May 13, after, I guess during the verdict or after the verdict, the judge, put on the record that she had, something about this, I guess, I love you letter to Judge Tydingco-Gatewood and all her staff, and it's from the best jurors. And I'm still trying to figure this one below it. Date, FEB, then AS, and eternity. Dash eternity.
And it was signed by 15
and it was
people?
Signed,
16, I believe.
16?
It was signed by 16, if I may say, idiots.
So does that mean 12? Because there are 12 jurors. Were there 4 alternate
Yes.
jurors?
That were
Yes.
left
Okay.
at that time.
But so now that we know that there are 16 signatures here. Remember, I was not present when this was. Okay, but according to the judge, the jurors left something on the 7th, May 7th.
On May 7th,
Yeah.
which was the morning of the rebuttal closing by Ms. David.
That's correct.
Okay.
And on May 7th, I was on a flight to Thailand. Okay, but my understanding, and I've discussed it with Mike, Bill, and Joe Rosano, is that no one knew about this, love letter on May 7th. And no one knew about it until the verdict on May 17th. Okay?
May 17 is the day of the verdict, or May 13?
I'm sorry. May
May 13.
13.
Okay.
Until
When you
the
say
verdict.
no one, you're talking about no one in the defense knew about it.
That's right.
But the judge and the judge's staff had to have known about it because the jury left this for them
Yes.
on May 7th.
And so this is something that, there's no way that Judge Frances Tydingco-Gatewood could say that she didn't know about the existence of this, because it depends on what's being said, but this was left somewhere in the courthouse, okay, or it was left with one of the court's clerks, but the important thing is that there's only one person tasked with knowing, with the, with the obligation of knowing everything that goes in that courtroom. There's only one person. It's not a clerk. Huh? It's not the law clerk. It's Frances Tydingco-Gatewood. She's supposed to know everything that's going on. Okay? And so, and so she had to have known of this since, May 6th. She had to have known of it.
May 7th.
7th.
May 7th.
And then she keeps quiet about it. And then, you have the transcript of May 13th where she talks about the note, and she tries to, I guess, she tries to minimize.
That it's not a big deal.
That's right. It's not a big deal.
Why is it a big deal?
Huh?
Why is it a big deal?
Well, first of all, because she knew about this since May 7th. She knew about it. Okay?
And failed to disclose.
And she didn't disclose. Her obligation is immediately to have told the defense. And immediately, she should have called us, called the defense, called the prosecutor, and have a meeting and, and really end the case.
Would that have, if she had told you on May 7 or May 8, and the jury was handed the case on May 7, correct?
Yeah.
The jury was handed the case on May 7. If she had informed you both or all of the defense and the prosecution about this card on May 7 or May 8, would you have moved for a mistrial?
That not only that, there could be someone out there, but I don't know of one. I don't think there's a single defense attorney that would not immediately move for mistrial.
Okay.
Now, of course, that doesn't mean that the judge would grant it. I think she should have, and that's part of our motion, as the other attorneys have argued also. I think everybody sees eye to eye on this. It telegraphs, but the tragedy is that the court knew about this before deliberations even began. And so let's say that the judge were to say, no, I think it's harmless. At the very least, we could have maybe convinced the court to give the jury then one more instruction, and that is, come on guys, you've got to think independently. Don't let anything that happened during the trial that's not related to the evidence, bother you, and possibly allow us just to ask some questions, because they could have maybe had an explanation. But now, you've got the transcript of what the judge says she knows. The defense has no idea how this happened, why it happened, why it was kept a secret. We were called for any other note that came in. I think we were called 2 times, maybe 3 times, the moment a jury note came in. And so this is, very, very significant.
I looked this up, so I know the answer about the public records. There is no instance throughout the country in a federal trial in public records of a federal jury sending a federal presiding judge a thank you note prior to a verdict. In your trial experience here in the local courts and also in federal court that might not be public records, have you ever seen a jury send a note, a thank you note to the judge?
Can I answer?
You've done a few.
All right. Okay. First of all, look, honestly, I think I've told you, I've done over 700, jury trials in my life.
Over 40 years, right?
Over 40
years.
years. Well, 45 years. All right? And we've never seen the likes of this. And I doubt if you're ever going to see it in any other jurisdiction.
I looked it up, and according to the public records, there's none. This is going to be the first.
That's right.
Okay.
And so, the thing is, it is so dirty that even a judge not as intelligent, rather, even Judge Tydingco should have known immediately
that
to
it's a problem.
stop this. Okay? to stop this, because one of the things that is told to a juror every day, at the end of every day session, there are two things that normally happen when, the trial ends for the day. The jurors are told by the judge that, leave your notebooks on your chair. And one of the marshals will, pick it up, put it together, and then put it back in its place the next morning. That's one. Okay? The other thing is that they're not to talk
To each other or to anybody else.
about to each other about what occurred that day. Okay? Now, which means that these people, when they sign this thing, and it appears that there's 16 signatures, okay? Which means that there's the 12 jurors, the first 12 jurors, and then, there were 4 alternates probably that were remaining as of May 7th, okay? And they all signed this. And then they sent this, "We love you, Judge Frances Tydingco-Gatewood" letter, along with her staff. Her only, choice at that point when this was, late, or rather, deposited with the, one of the court clerks, or wherever it was, was left at, she should have immediately, this would have gone to her. No court employee is going to keep this away from the judge. Okay? And so, what do you call that? She should have, once she sees it, she should have immediately brought all the defense counsels and their clients, and brought these, 16, idiots, and told them, and should have told them, you've been instructed you are not to talk to each other about the case. But what's even worse is that not only are they not following that instruction, but what they're doing is that, they're approaching the judge already. They're talking to the judge.
Which is against the rules.
Ex parte, it's
Well,
called ex parte contact. You can't
That's
do that.
right. That's right, Mike. It's an ex parte contact. And she has an obligation to bring in the defendants and their lawyers and tell them about the ex parte contact.
And that never happened until the verdict.
Up to now, yeah.
We don't know.
Up to now.
Obviously,
Up to now.
Dave's guessing, I'm guessing, and you'll see in our motion that what the judge said after everything was finished, after she discharged the jury and they were out of the room, is significantly different. Just because both are incomplete, I can say that, from what came from the clerk's office. But when you read both, you'll see that at least 50% of the statements are what you can call in the passive. So they won't say, for example, Mike gave me this. They'll say, it was left. It was left. Doesn't say very much to you. And it's the same with the clerk's office. It wasn't stamped. There's no explanation as to why it wasn't filed, but it was said.
But it was left on May 7.
It was left on May 7, but the record from the clerk's office, the transmittal, doesn't come to the 13th, and in that transmittal, the clerk states affirmatively something to the effect, and I'll give you a copy of the motion because it's all in there, in good faith and full transparency or something like that.
Yeah.
Now that comes on the 13th, but the clerk makes it clear that it was given to the judge in chambers on the 7th, I
Okay.
believe. But see, we still don't know because we got two statements that that appear, either they may not know either, because the jurors were not asked. We don't know which employee received it. I mean, we were there watching, and after closing argument, you have the instructions, and of course one of the instructions not to contact the judge like that, but they all left, and so we didn't see anybody drop off a note or anything like that. That would have been obviously so improper that everybody would have seen it, and so we watched. And so how and where this happened, we still don't know, and we were never allowed to ask. We've not even been able to ask the court.
Will you guys be filing? Will either of you or any of the defense counsels be filing a complaint against Judge Tydingco-Gatewood with the Ninth Circuit regarding her conduct? Judicial misconduct, I think, is what it's called.
I want to beat all the other defense lawyers to that answer.
Okay.
I will be doing that, okay?
Okay.
And I hope that my co-counsels will join me, because there's nothing as dirty, that can occur than a judge who hides things from the defendants and their counsel about a communication between the judge and the jury.
Okay.
Because this is what this is. That's all it is. But I guess she wanted, to look at this and kiss the hard part there that says, to Judge Tydingco-Gatewood and the other, the clerks there, and from the best jurors. At that point, she knew there was nothing but dirt there. There was just, she had an obligation to immediately put a stop to this.
Because she should have known, as a jurist, she should have known that the jury was clearly tainted.
Well, it was, but also let's talk about what this message is all about, okay?
Okay.
This message, I believe, now we're all guessing here, because we haven't interviewed anyone here.
Because the jury was already discharged by the time you knew about the message.
That's right. They were already, and after the verdict. But, there are 16 black spots here, right? And then, there are messages on each of them, okay? And so I believe the 16 are
The
the
signatures.
12 jurors
Yeah.
and the 4 alternates.
You're talking about their names and their signatures.
That's right.
Okay.
And then they all, with the exception of one person who was very laconic, everyone tried to, butter up, Gatewood. Okay? And so the 16, which means it's 12 jurors and 4 alternates. In other words, closing argument was not yet finished when this occurred.
Because it was left on the day of closing arguments.
Well, it was left on the day of, and so,
and someone had to draw all of that, and then they each had to make their
it
messages.
had to be done before,
Okay.
before what? May 7th.
But the point is that it was done even prior to the case being handed to them, prior to
Yes,
the deliberations, prior to
before
the verdict.
You're right,
Yeah.
before deliberation.
How long it took them to do everything they did with it is, we're just speculating,
No.
but most people can tell that's not like an hour's work.
All right, let me ask you guys: isn't this sort of like a blessing in disguise, though, or do you feel good
Well,
that this happened? Because
can,
otherwise, you would not have
yeah.
been able to tell this story about the bias that happened since the Hansen case. This sort of just wraps it up in a bow tie for you. So you have to. What are you feeling about this?
If I can
Yeah, go ahead.
answer it from my perspective. A lot of it just comes from watching Dave all these years. I remember we were in a case together, and it was a juror that I was questioning. Was very clear that she and I were clicking. She was giving all the right answers and everything. So I go back to the table, and first thing Dave said is, you got to get rid of her. I said, I know, because those are the rules. And it comes down to this, and it's one of Dave's expressions: I don't need any favors from anybody. We just be fair, and I'll do my part because we have the confidence. And in this case, absolutely.
I do want to talk about the case itself, but let's wrap it up with the card.
While the errors do, just like with Dave's experience with Rufus, the errors, I believe likely will lead to a reversal. Hopefully, though, we get a new trial and we don't have to go that far. It's really not what we look for. We look for the win, and it's in cases like this. I think the odds are very favorable to the defense. If you just honor the Constitution, the Organic Act, and the rules of court, if things go fair, we don't need any favors. But you're absolutely right. When these kind of mistakes are made, now. But we don't know what
you're saying. You're saying you didn't need any favors.
Left.
Yeah, you're saying you didn't need any favors. But what you're asserting and what this card shows to the naked eye, right, is that you weren't gonna get a fair trial.
No, but in fairness,
isn't that what this is saying?
In fairness, Troy, to the system, if you gave us a few hours, if not a few days, of voir dire to speak to these jurors on the front end, I would say probably 90% of these guys would not have made the jury.
But you weren't given that.
No,
you weren't given that, and it was because the judge doesn't like.
One day.
It's because the judge doesn't like Mr. Lujan. It's what your assertion is, right?
Well,
but what I'm saying is that if all of that's true,
yeah,
none of this could be litigated, argued in the public's eye, had that note never came to light.
No, I think we already had a number of what we perceive to be very serious
the
errors.
mask and the...
yeah.
So there are other things, but this just sort of crowns everything,
trial.
Right?
Yeah, this really goes more towards the jury, though, And again, we can go on and on with the mysteries, right? Just look at any of their messages, and you're not able to really reach a conclusion because they're mysterious. But so is the delivery. Because if I really didn't know, I would walk up to the judge, and these guys, the attorneys would say, "Mike, what are you doing?" "I'm just dropping off a letter." They'd say, "You can't do that." But that's not what happened with the jury. The jury knew not to do that in public. They knew not to do that in front of us. So, when they did it, we still don't know. But if it was after the jury instructions and they had heard the warning, at least read by the judge, that you're not. There's a certain way to communicate with her, and only for certain things, and they had done that for with other jury notes. This one wasn't made public though, and so again, if it was all innocent, they would have made an innocent mistake and stood up and said, Your Honor, we have something for you. But that's not what they did.
And the judge would have said, "I'm sorry, I can't accept that."
Yeah, absolutely. And of course, we would have said, "Can we see that?"
Yeah.
And then we would have had a discussion. But I want to stress that, this won't be the first time that the judges overruled something that we've asked, but there's still a benefit because at least the record is made. And rather than speculating like we are now, we have no idea what was going on that would create that letter. That just doesn't happen, as you know. So what happened?
What are your thoughts on what's going on that created that letter?
Mm-hmm.
What do you think the jury was thinking when they created that letter?
A lot of artwork.
Well, they wanted to display, that they're not a fair juror. That's one. Number two, they wanted to display that they don't know how to follow instructions from the court. Number three, apparently they believe that Gatewood is as corrupted as they are. Okay? Because if there are 16 people that signed this, someone among the 16 people would have, say, "Stop it, guys. We need to stop because there's something wrong here." But apparently not. So I have to say that these 16 people really are corrupted, number one. Number two, they should be banned from ever becoming jurors in any other case. both in district court and in superior court. They should really be banned because, these are people that think that whatever their plan is, it supersedes any instructions, legal instructions that are given on a daily basis in every criminal case in the entire United States, and that includes one. These are people that should be banned. But what is also sad is that even the judge and her staff who are mentioned, if they have not filed a complaint, an ethics complaint against the judge from not doing something, then, the judge has sort of gotten them, to become part of her. Because every fair person, and that includes, that does not, it's not limited to the jurors, but everyone that's a part of the trial and whose name is mentioned in this. And when I say part of the trial, meaning as, a member, of the of Gatewood's courtroom, okay? All of them should reject this because, they've been subsumed as being, in the category of these 16 people. So these, but so you have to believe that if they did not file a complaint, with the judge or with, with, I guess, whatever ethics, body exists that deals, with district court matters, okay? If they didn't do that, then they're equally as dirty as the 16 people and Gatewood, okay? So, at this point, honestly, I really believe Gatewood has no choice, really, but to resign. And we must not forget, Gatewood was appointed a judge by, I believe, President Bush in May of 2006, okay? And the appointment is 10 years. Their article for judges. Guam, Saipan, Virgin Islands. Okay? And on, I believe, 2016, 10 years after, after she had served 10 years, I believe Judge, what's his name? President Biden. No, not Biden. Obama. President Obama, forwarded Gatewood's name to the Senate, and the Senate, returned the nomination to Obama. So, Gatewood is a holdover judge, nothing more. And I believe in December of 2024 or before that, Biden, announced that he was going to forward Gatewood's name to the Senate. But Biden ended his, presidency without ever sending that to the, to the, what do you call that, the Senate, which means, that Biden, I guess, was advised or had, information that, that Gatewood is not qualified to be a judge. And now, when you look at this, so-called love letter, okay? You can't, you have to believe that these people that rejected Gatewood, were smart people. And you would hope, that Gatewood, she's benefited. And she's been a judge for 9 years past her 10-year service, that if she had any honor, you know, she would apologize not only to the defendants and, you know, and defense counsels, but also to the entire people in the district court, you know, hierarchy, and apologize to everyone, really, and to all the judges, the federal judges that come to Guam, you know, helping her. Judge, what's his name?
Gunnar.
Connor, Judge, you know, Munson from Saipan, who's retired, Judge Manglon, yeah. She should, you know, retire, rather apologize to all of those people, okay? Because you know what, honestly, it's not what those other judges would do. This Gatewood should be ashamed and, you know, and resign, because that's all, that's really what, you know, what, I guess, you know, there's no other way other than doing that. I believe that, you know.
In the meantime, you, Mr. Phillips, have filed a motion to set aside the verdict because of this and those other issues that you raised, correct?
Yeah, there's two remedies. It's really asking for an acquittal because the government really didn't present the evidence that would be sufficient.
I do want to talk about that, but yeah.
Right. And then the second part is the new trial. That's a separate remedy, and that comes from this.
Okay.
So we're asking for both. But for this, our client's also asking that Judge Gatewood not be the one to conduct that hearing, obviously, because it involves her directly. I think without doubt she could have said, "And I know nothing more," but she didn't say that. And no one else, as Mr. Lujan pointed out, no one else in the courtroom filled in the blanks. So we need to go forward with that, and it just seems, you know, the test is really one of, is there an appearance of impropriety? I would think when you're being judged, right, that's part of it. If she's being judged, as others are, that they shouldn't be the judge of themselves, or at least allow a separate judge to make that ruling and say, no, you can go ahead and be the judge. It's not a big deal. Or say, you know, you're right, and I'll handle it. And in fairness to the defense, I think when you're looking at that standard of whether there's an appearance of impropriety here, that standard, in my opinion, is easily met with all the stuff that we just don't know. But from the little that we know, you know, it appears from the lack of any notice that at least for 6 days the decision was, don't let the defense know. And the fact that we were not told until after the jury had been discharged, again, it tells me that there was an affirmative decision, don't tell them yet. That could have gone another day. We might never have known about this. And since others in the courtroom did and didn't say anything, they were also very clear that it was left with the judge in her chambers. It goes without saying that, you know, they don't have the authority. You know, it's kind of like a whistleblower thing. Like, they don't have the authority to call us up and say, hey, you guys need to know that there was a special, you know, as it's been described, the love letter that came from the jury. They don't have the authority to do that. It's something, as Dave mentioned, it would be the ethical thing to do, and people's lives are on the line. But yeah, when that sat with the judge, there's nothing saying that we were going to be told this when we were. I mean, every day that went by that we were not told is indicative of the fact that, well, you know, there's just been a decision made that what the defense doesn't know won't hurt them. And then, fortunately, although, you know, you see in the motion the description by the judge is very different from what we found. I didn't see this till probably that evening, maybe later that night, because the description, if you read the description the judge gave, it's not anything, you know. In fact, I think somewhere there she said, you know, you guys will get to see this. Well, we didn't. That night, it blew my mind. I saw it on my cell phone. I'm like, oh my God. And so I sent it to my client, and everyone that saw it was just completely blown away.
This isn't one of those things where, you can step back and say, it's just a nice letter from the jury to the judge. What's the big deal?
You can, but the chances of that are very, very remote. But you can, if those 16 jurors were able to, look at us and our clients and explain like what you just said, then I think we'd probably not think very highly of them. But, we could at least conclude, they're just, they just violated every rule and all that, and maybe not have much respect for their intelligence, but at least the intent maybe would have been made clear. But we were never given that chance. It's not just the jury; it's the idea that this was handed to the court, and the court had no idea what. It appears the court had no idea what to do with it. I mean, so it was just a quick note. Anybody can call us. It could be the judge's immediate staff. It could be the clerk of court. It's not a big deal. It's, Mike, there's a note from the jury. Not a big deal. I haven't gotten that phone call from different people. But this one, nobody touched it. No, it appears nobody knew what to do with it. As you said, in recorded history, there's never been anything like this. But that's the time you call up the attorneys and say, boy, you guys, we got to meet, and this one's going to take a few hours. But absolutely nothing. And you listen to the description. You read that description and you tell me if that would have alerted you, because I'll be the first to admit it didn't alert me. And when I looked at this later on that night, I'm like, oh my God. But it wouldn't have mattered whether we were alerted by that description or not, because the jury was gone and they're discharged. And more important than anything is this happened and the court knew about it before they began deliberations, because even when they were let go that morning, they were told not to come back till after lunch. And so whether this was found before the jury instructions or right after closing or right after the jury instruction, it doesn't matter. All of those options, whichever one it was, happened hours before they began deliberation. And that's where that dome starts to take place. Once they begin deliberating, that part of it, not the outside part of it, but that part is very well protected. They rarely let attorneys probe into what happened in deliberations, but this was before. And it, like I said, it put the court in a position, it appears, by not telling us that even the court had no idea. I can only imagine that the court was researching as much as we were, and you may have, and at least in the commentary we've received so far, there's not a single message from the court that it had looked it up and knows what to do.
Mr. Lujan, you started to laugh when I raised the possibility that what if this was just a little note, a harmless note, and you started to laugh. What? So you explain to me your thoughts.
Because it's not. It is harmless, rather. It is very harmless. Rather, it is harmful, rather. And what to me, I guess one of the things that really affects me, okay, is that we have a Chamorro judge, and we are Chamorros. And this judge is more interested in, herself. And she doesn't realize that by minimizing what happened with this so-called love letter to her, and without informing the entire, defendants and their counsels, without informing that and being honest about it, she has really denigrated what it is to be Chamorro. Okay? I take pride in the fact that I'm a Chamorro, and that, and that I've done a lot of, trials, and I try and do it as honorably as I can. I don't win everything, but I do it to the best of my ability. I cry with my client when my client loses. I laugh with my client when a client wins. Okay? But we do it honorably. Okay? And so, this judge really has betrayed her obligation as a judge. And so, I really believe that she needs to retire. She needs to leave because she's shown she's not fit. Okay? This is a judge with a lot of reversals. Okay? A lot of cases where the Ninth Circuit reverses her. And so, she's brought dishonor to our race. I take pride in being a Chamorro. Okay? And I despise it when another Chamorro, denigrates us. And, this is coming from the most, I used to tell Gatewood, I used to tell her that she's the most powerful person on Guam. And she would say, oh, don't say that, Dave. And I'd say, yes, you're the only person that you can even summon the Supreme Court justices to your courtroom. No one else can do that. They can't summon you to their courtroom. Okay? But, of course, she's more interested in, in her ego. Okay? And that's what this is all about. Nothing but goddamn ego. Okay? And so, there's just no excuse for this. Okay? I'm sorry for the cuss word, but it deserves it. And every one of these 16 people, honestly, should be investigated. Should be investigated. And, but not by the FBI that's stationed here in Guam. Okay? It should bring in, FBI from another jurisdiction, Hawaii, California, wherever. Hell, even Saipan would do a better job. And so they should be investigated, okay? And they should be honestly, punished for what they did because they engaged in an illegal act, with a judge, a federal judge. No one can excuse this. No one should excuse.
So this is a big deal that cannot be excused.
That's right.
As just something harmless or.
They have to be investigated. Everyone. They are guilty of something already. And so they should be, what do you call that? A case should be brought against every one of them, including those 4 idiots too. The 4 people that, the 4 so-called, what do you call that?
The alternates.
Alternates. The 4 alternates. Their ego is so big that they want to be part of something that they wouldn't be part of once they're discharged. But you know what? It tells you that because once a case is, given to the jury, once closing argument is finished and jury instructions, closing instructions are read to the jurors by the judge, then the case, is the judge tells them, you go in that jury room, select a chairman or chairwoman, a chairperson, and then deliberate. Okay? That's the only thing they're supposed to do. Deliberate and come back if there's a verdict. And if there's no verdict, tell the court. That's all. Their job is not to kiss ass with Gatewood. And their job, is not to make Gatewood's ass bigger than it already is. Okay? She should be ashamed. Honestly. Because you know what? I guarantee you, we're not going to find any other jurisdiction that has experienced this. Okay? And that has brought dishonor to our island, but especially to our race.
Mr. Lujan and Mr. Phillips, I want to close with the central argument or the central theory of the defense versus the central theory of the prosecution and how the judge treated this. So central to the defense's theory of the case is that this was not illegal gambling, and so therefore the money that was moved was not laundered, there was no wire fraud, etc. Central to the prosecution's theory of the case is that it was illegal gambling and that the defendants knew it, and then therefore they conspired to launder money and to commit wire fraud, right?
That's fair.
What did the judge do to color this in favor of the prosecution's theory, or at least against the defense's theory? Because the judge is the arbiter of what the law
Sure.
is, right?
Right.
Okay.
Yeah, it wouldn't allow me to cross-examine the IRS agent on the fact that she knew that their star witness was a member of at least 2 existing bingos right now. And
You're talking about Wan Sun Min.
yeah,
Yes.
yeah. And when I talk about her, I talk about them because she's not just their first witness in terms of the first to get in trouble in a different case. And while she was in trouble, I guess she became their star witness. But you know, that really goes to credibility, and to not be allowed to discuss that, because you know they sat, the prosecution and the IRS sat right there watching her say things that, in my opinion, they knew were not true. And the moment I began to discuss that,
As to the credibility of the witness.
yeah,
Okay.
even with that, and that's one thing that's always relevant is credibility. I was not allowed to, and that was frustrating. But I think theme-wise and even more substantively was the fact that we had to defend kind of against the boogeyman, because we couldn't see it. Our clients had met their obligations under their applications. Some people apply to be nonprofits so that you know their family and friends can take golf lessons and every other kind of civic purpose there is out there. I don't mean to make fun of the golfers, but the Shriners, these guys were raising money, working all night to send kids to Shriners Hospital, and the evidence was very clear. Never once did they turn down a single request. They always met that obligation. And so the idea that they were probably either going to be or were also the most successful bingo operation on Guam was held against them. Mr. Lujan's final, I think it might have only been his first and last question of one of the witnesses they brought in from Hawaii that is kind of in charge of the Shriners. And so Dave had asked, now that the Shriners are no longer, running the bingo operation, did anybody step forward to help the kids? And the answer was no.
I read in one of the reports, I think it was by the Guam Daily Post, one of the things you said was that it's not illegal to make money, or it's not illegal to want to make more money. But would you, greed is not a crime either, right? But was it your impression of the case that it would be hard for you, or that the challenge was to convince a jury to set aside any hard feelings that they might have about, Mr. Marasigan or Mr. Chan or Mrs. Chan making money, or their appearance that they were greedy, separating their feelings about that from what the law says and what,
Yeah, well, if the government weren't allowed to say that, or to, because the government said that, and even before I would object, one of the other attorneys would object, and we would be up at the bench for probably 10-15 minutes just on that, and the judge would allow them to make that inference.
I see.
And so, and when I say allow an inference, what I mean is either the judge or the prosecutor might say, for example, oh, we're admitting it for a different reason. Like, what other reason? You're admitting it so that this jury will hold it against the defendants.
So
that,
these clearly prejudicial
Clear.
things were
yeah,
entered
and
in
in
front
our
of the jury.
in our opinion, just not relevant. I mean, it's just not relevant. And so yeah, when at the end of the day, you have to realize you're defending not just against, is this illegal, because it's not. You're defending against the fact that they made a lot of money, and what they don't know, right, which others know. For example, like my client, when the pandemic hit, he was left holding the bag. My client's been sued. That's how I met him. Long before he was indicted, he came to me for help because he was caught, as they say, holding the bag. He had to pay the rent, and his name was the guarantor on the lease agreement. And so they don't see that side of it. A good 2 or 3 years, but the problem is when you're that's why you don't find that many people involved in sponsoring bingo, because it's very speculative, it's very risky. And if it was a great business, then all Guam's businessmen would all be in there. They're not, because you can do well. But at the end of the day, when you do well, and you're the only bingo operation indicted on the island, and no one will explain why. There's no explanation for that up until today. And in fact, in my cross-examination of one or two of the witnesses, well, definitely the IRS agent, she tried to explain that the people that run, I call them the money people, they swipe the cards and all that, they're not indicted. And she said, no, that's different. It doesn't really go into an account. The Aloha guys from off island, these are all big boys now, right? In terms of society, right? These guys are big boys, and I don't mean that physically. I mean from their stature. They're not going to touch them. Yet they receive money from the people from Guam, and so they coordinate everything with regard to the fact that the Shriners from Guam pay for the trips. In fact, I think it became very clear, maybe not to the jury, it should have, but to all of us in the courtroom, that one or two of the government's witnesses didn't even know that not only was Guam giving money to the Aloha Shriners, and they're deciding what to do with it, but Aloha didn't know that Guam was also funding every request that came from Guam. And they thought, and I guess that's what most Shriner organizations underneath the father organization do, is they send money, and then the father organization, so to speak, they decide where it goes. So that was the testimony, and it was undisputed that the Shriners from Guam funded every single request that ever came. Every single request they paid. And so, the government...
So no child was disenfranchised
Never.
by the scheme?
No, absolutely not. No, and all they've ever pledged is that's what they would do. They didn't say we're going to find a cure for muscular dystrophy or anything. They didn't. They just said that this is, and again, and I don't mean to belittle anybody else, but you're not going to find any mission that I've seen out there. There's not that many, but there's a few. You're not going to find any mission that stands up to this. Some are trying to better their communities, and others are looking for golf scholarships. And if you fail on that, or you don't meet your goal there, it's no big deal. The Shriners, they set a pretty lofty goal, and they always met it. And you have these guys go from like in the case of Art Chan, go from work all day long, and then he goes to the bingo, and never a problem, for example, with an audit or anything like that. Nothing local. Just out of nowhere, they're indicted, no explanation, and really no difference from anybody else. That is apparent to me, or that came out during the trial. Nobody ever testified to that. Nobody even came close to explaining why those guys from off island are not indicted, why their star witness, who's participating in a number of other bingos on Guam, is allowed to do that. They allow her to do that. They knew that while she was on the stand, that she was committing perjury, because they had the FBI go out after we put those people that at least one of those individuals that she spoke to on our witness list, and they went out and they confirmed with that person that yes, their witness was lying on the stand. and didn't do anything about it. But you didn't have to wait for that. If you were watching, you could see, oh, she's lying, because we would get the tip. And in fact, Judge Gatewood mentioned this in one of her opinions, that she would see me walk up to Mr. Lujan, hand him a note, and then Dave would read it. Did you call? And he would just confront her right there. Did you call at 12:20 today? And so and so. And she'd say, no. And the people that she did call are the ones telling us. And so, yeah, it was, and it's one thing if you can sit there as the prosecutor or the IRS or the FBI and pretend you don't know. Well, that ended the moment we put those people on the list and they went out to interview them. And so at that point, you can't hide from the truth anymore, because the FBI went out and
yet the U.S. Attorney's Office is not charging.
Yeah,
this.
no, perjury. No, that's their star witness. Yeah, that's their star witness, and those were the questions that we thought, in all fairness, they should be asked. But
and she was offered no prison time in exchange for her testimony in this case. Is that correct?
I don't know what
because she was indicted and
in a different case.
She signed a plea agreement,
right,
related to this bingo.
Yes.
No, in a different case.
Yes, she has
She's only cooperating because her relationship with like what do you call that, Al Leon Guerrero. Remember?
But
Yes.
she had the
That's
business
right. Some of the
relationship with
checks.
Michael Marasegan
And Mike.
Yes.
Yes.
Yeah.
And so
So she's like a defendant, but she wasn't.
she
indicted
never went to
that
prison.
I know of. Yeah.
She signed a plea
Yeah.
agreement.
But
she
no,
never
but
went
she
to
has.
prison.
But she has another case.
Yeah.
She has a plea agreement in another.
Yeah,
Yes.
and that's how she and the prosecutors, I guess, got together.
Oh.
But if for example, that's okay, then you would think that the at least two that we're familiar with, and there's probably more that we're not, at least two ongoing, that she would have done the same for them. She would have been their star witness, and those bingo operations would have been would have received indictments, but none at all. And the government knows all of it. Yeah. And you could tell from even the witnesses that did testify. They had four. One had absolutely no clue what she was doing or what she did. The others that Dave crossed were very, very clear that with the assistance of the other defense attorneys and the cross-examination by Dave, that when they were told, this is not illegal, there wasn't a single one of them that said, I don't care, I still want to plead guilty. No, they were all but asking. One asked, well, if I'm not guilty, can I just leave? Another one, if he didn't, I think he wanted to ask the judge, can I withdraw my guilty plea? Because, they weren't told that. The record's pretty clear, very clear, that they were told by the feds that, this is against federal law. And they rolled over. But our clients didn't. Because it's not against federal law. In fact, the federal law, ironically, was changed in 2013 to remove bingo as being prohibited. So bingo's no longer against the law with the federal government. The feds have to find a location where it is against the law, and then come in to help the local people, and that's what they're alleging here. But there's no indication that the local government needed any help, wanted any help. The contribution that the Shriners were making to the local treasury, to revenue tax, is amazing. The amount of taxes that they pay is really, really high. And that doesn't include what the winners pay, and so it just goes on and on. Then the employees, et cetera, et cetera. So it doesn't seem like the legislature, revenue tax, they received a commendation. It doesn't seem that either the legislature or revenue tax would have any reason to not want them to continue. And of course, the Shriners, they did very, very well.
To wrap this up, gentlemen, you filed the motion yesterday, the motion to set aside the verdict and motion for a new trial. What happens next?
Motion for acquittal, meaning we want an actual acquittal because the government didn't meet its burden. And then the second thing that we're asking for, because of the love letter, is a new trial if we don't get the acquittal. Yeah.
So what happens next? Are we just waiting for the court to reply to your motions?
The United States Attorney should reply, respond, and then we reply. And so we should be given one more chance.
No?
Should be, yeah.
2 weeks.
In the
Yeah.
meantime, your client, Mr. Marasigan, is scheduled for sentencing in August. Is that correct?
Right now, yes.
And Mr. Chan and Mrs. Chan as
Yes.
well? Okay, okay. Where do you see this going, Mr. Lujan? You're the one with, you're the veteran here. Where do you see this going?
Ninth Circuit.
You see
If
the
she
judge.
doesn't dismiss it.
Do you see the judge? What do you see the judge doing?
Huh?
What do you see the judge doing? Do you see her digging in her heels and dismissing your motion to dismiss, or do you see her admitting to any of this?
Well, I mean, let's face it. She's beholden to these people. So she's going to try and keep, probably deny everything.
Okay.
Okay?
And so that's why you're saying this
Yeah.
is going to go to the Ninth Circuit.
Well, yeah. I'm going to go to Ninth Circuit.
And your client is prepared to go to the Ninth Circuit?
Of course.
Okay.
I mean, there are good appellate lawyers.
Okay.
And there's a guy that has won 2 cases already in Guam.
Reversing Judge Gatewood twice?
Well, no.
Once was judgment Glotnia, but it was local. We had initially, after a verdict announced our motion for an acquittal, and that attorney came in and helped with that, and it didn't have to go to appeal. In fact, he did the arguments, and to the judge's credit, it wasn't Judge Gatewood, it was Judge Maglonia. To her credit, she saw the absolute need to dismiss the case, and
Writing
so
on the wall.
yeah, so she entered a verdict of acquittal
Okay.
for our client, and so the U.S. Attorney's Office in D.C. spent a lot of time deciding whether they were going to appeal, and then they just decided they were not going to appeal. I remember it didn't, and that's how that ended. And of course, in the other case with Rufus, it went up to the Ninth Circuit, and same attorney, and it was reversed, and that case is completely over. So here, I'm hoping that it's more like that the one experience before Judge Manglotnia, where the judge goes ahead and rules. Because what the judge will rule here is that the government just didn't meet its burden with regard to this illegal gambling stuff. And if she agrees with us on that, I believe everything goes away. It's nothing personal, it's just they didn't.
You're talking about the crux of the case.
Yeah.
The theory is that this wasn't even illegal gambling.
Well,
By the local
me and the
statute.
judge have a healthy disagreement on that. I don't think it is, and she, I think, believes that that it is illegal on Guam, and she's the judge, so her decision controls. But even with that, the government didn't meet its burden, and so she doesn't have to change her mind about believing that bingo's illegal on Guam. She just has to agree that the government didn't meet its burden, and so she really doesn't have to change her mind with regard to her stance. She doesn't have to agree with me. I don't think it's the legislature, I think, spoke very clearly when it drafted, well, not clearly, but it indicated that it didn't want nonprofits that are conducting bingo to be held in violation of the law. And so it could have been clearer. So I believe that the judge has made clear she believes that bingo is illegal without special conditions. And so even with that view, the government, in my opinion, just didn't have enough evidence to sustain a conviction, so the judge could still enter an acquittal, and we all go home. It doesn't go to the Ninth Circuit. Yeah, but without that, then I believe we're entitled to know lots of things with regard to the love letter. Why was the jury dismissed? Why weren't we told what was going on for the 6 days? Who did they leave it with? And that's not even getting to the jury yet. If we were allowed to ask them, what the heck is this? I can only imagine that 16 of them could have 16 different versions of what happened.
But at least you'll know who started the conversation. Someone had to have started the conversation.
It won't take long to figure out once we start, once just they answer a few questions, because the love note speaks for itself, you know, and so just having them attempt to explain. I noticed recently that there was a back, because when I found it that night, I was scrolling down and there's a big white space. But if I had gone further, I would have seen that apparently it's a card, and it was I think it's made in China, and it's a Christian production of some sort.
You're
And-
talking about this.
Yes, yes.
Do you
And
have that?
No.
I can't figure out what it means.
These are the names of the jurors.
And we can have that.
Huh?
We can have that.
Of course.
Thank
And so what that
Troy,
second
anything for you.
what that second page means is, I think there was, it
We
was
all
obviously
have the same
photocopied.
goal. I think so. You know,
When you look at it,
let me get a copy.
you see, you know that stuff probably better than me. The only reason that the clerk's office would have that is it was two-sided, and that means it wasn't downloaded off a printer. It means somebody went and bought it, or they had one at their house. You know.
I see. I see what you're saying.
Yeah. What? Have you read through the individual messages?
Yeah.
Okay.
There was
This
even
one's,
one in
please,
tomorrow.
off the record.
Yes. Oh, okay. So we're done with the
Yeah,
we're done
yeah.
with the interview. Thank you so
No.
much, Mr. Phillips.
Sure. Sure.